All right, well, good morning. Welcome, everybody. My name's Jeff Rosen. I'm a non-resident fellow here at AEI. I'm also a practicing lawyer who's handled antitrust cases, both in private practice and when I previously served at DOJ as Deputy Attorney General. So I'm very much looking forward to today's discussion about the current path of antitrust and consumer protection at the Federal Trade Commission. With today's speakers, I think we're all going to hear some great insights. So I welcome all of you here today, those who are in the room, those who are on the live stream, and my understanding is I think this was also going to be on C-SPAN. So one preliminary observation as we get started. Today's topic is the Federal Trade Commission at the Crossroads, the path forward for competition and consumer protection. This topic somewhat reminded me of many years back when I first came to Washington, D.C., shortly after the Carter administration. The Carter FTC under Chair Michael Perchuk had adopted novel legal and economic theories and had pursued a blizzard of unusual activities for the FTC, and they went through some rough sledding in the courts and in Congress. So when President Reagan was elected, new leadership was installed at the FTC. Jim Miller became the chair, and Tim Uris became the head first of consumer protection and then of the Bureau of Competition. And at that time, it was clear there would be a change in direction, but the specifics of what was coming were not so clear. Now, of course, in hindsight, they are today, but they weren't initially. So if we fast forward 40 years to the very recent period of the Biden administration, the Biden FTC chair, Lina Khan, proved similarly controversial, once again advancing novel economic and legal theories and unfamiliar rulemakings, and that again produced some major headwinds in the courts and consternation among members of Congress. And once again, after an election, we have new leadership at the FTC and new heads of enforcement who are with us here today. And of course, understandably, there is significant interest in the changes that are either underway or may be coming, both in antitrust and in consumer protection. These are issues that affect our economy, the cost of living, and the pace of innovation. So let me just briefly introduce our speakers from the FTC, who are Dan Guarnera, who's the director of the Bureau of Competition at the FTC, and Chris Mufarrige, who's the director of the Bureau of Consumer Protection at the FTC. Their full bios are available online, so I'm not going to take the time to repeat everything in those, but I want to highlight a couple of aspects about their qualifications that Dan and Chris bring to their roles. And I'm going to focus on some that are on top of their being graduates of top law schools. They're both having had experience in private practice at large law firms, and both having had very significant government experience before their current roles. In particular, I want to highlight a bit more about their government experiences. So in alphabetical order, just starting with Dan, Dan Guarnera has served in all three branches of government. Served in the judiciary as a clerk to Judge Sykes on the Seventh Circuit Court of Appeals, in the U.S. Senate on the staff of the Judiciary Committee, and in the executive branch at the Justice Department's Antitrust Division, where I recall his important work on the Google investigation, and he later became the head of the Civil Conduct Task Force at the Antitrust Division. Now he serves as I said, the FTC's director of the Bureau of Competition. Chris Mufarrige likewise brings a wide range of public service experience, but in a somewhat different way. He's served at 4 different federal agencies, all of which are germane to his current role. He's been at the Consumer Financial Protection Bureau, he's been at the Commodity Futures Trading Commission, been at the Federal Trade Commission, and the White House Office of Management and Budget. And now he's returned again to the FTC, as I said, as the FTC's director of the Bureau of Consumer Protection. I highlight this in part because I think their backgrounds speak to the genuine commitment to public service, to the public good that they bring to their roles, and it's something which many of us appreciate and I'm sure is helpful to their current roles. So we're very pleased and appreciative to have both of you here today. Before we begin this discussion with Dan and Chris, though, let me introduce one more participant for today, former FTC Commissioner Noah Phillips. Noah is currently a partner and co-chair of the antitrust practice at the law firm of Cravath, Swaine & Moore, LLP, where I am also of counsel, so I know him to be a terrific lawyer, a wonderful colleague, and a premier expert on antitrust, consumer protection, and the FTC in particular. Noah served as a commissioner at the FTC during both the first Trump administration and the first 2 years of the Biden administration. So his experience in the last 2 administrations makes him an ideal person to help guide today's conversation on what's coming next. And perhaps he can contribute his own observations as well. So with that then, let's get right to the conversation about the FTC's path forward. Noah, I'm going to ask you to get us underway with Dan and Chris, and I'll look forward to the conversation and join in along the way.
All right, well, thank you, Jeff. Thanks for being here, in particular, Dan and Chris. Thanks to all of you for coming, and thanks to AEI for hosting us. I just want to get something out of the way. This is the throat clearing that any senior official from the FTC needs to do. So on behalf of Dan and Chris, and I hope I get this right, they are just speaking for themselves today, not for the commission or for any particular commissioner. So with that said, I know just by dint of faces that some in the audience are very familiar with what the FTC is and what it does, but I thought for those who are not as familiar, those outside who are not as familiar, if you could each describe what your jobs are and what your bureaus do.
Sure. So again, very nice to be here. Thank you so much to AEI for hosting, and really looking forward to this conversation. So the Bureau of Competition is one of the primary bureaus at the FTC. We primarily enforce 4 antitrust-focused statutes, all of which are over 100 years old. So the Sherman Act of 1890, which prohibits illegal agreements and monopolization. The FTC Act of 1914, which prohibits unfair methods of competition. And the Clayton Act, also of 1914, which prohibits mergers that may substantially lessen competition. And as part of the statutory scheme that Congress has set up, companies, before they merge, have to give notice to the FTC of who the parties are, how much money is involved, what industries are they in, to allow the FTC and DOJ to review the merger before it's consummated, to make sure that it doesn't violate the Clayton Act. And so a lot of what we do is to review mergers before they're filed, determine whether or not the merger would violate the antitrust laws, and if so, we would move to block it, and if not, we would get out of the way and let the merger close. Turn it over to Chris.
Yep. Thanks to Noah and Jeff for having us. Excuse me, I've lost my voice this week, so forgive me if you can't hear me. So the Bureau of Consumer Protection, we enforce over 40 statutes, and but principally Section 5, unfair and deceptive trade practices. What the bureau directors do in particular is a bit unique, I think, in terms of roles in the government. Both bureaus and the Bureau of Economics report up to the commission and the commissioners. The directors, I forget the statute, it was back in, I think, in the Kennedy era, it was a reorg. The directors both obviously serve at the pleasure of the chair, but principally we do serve the commission. And our jobs are principally to shepherd the opening investigations, the investigations themselves, determining how to use resources, obviously, getting the chair's blessing on those types of things, and then sending packages up to the commission, whether they be rulemakings, cases, even guidance or other related types of issues, right? So really, what we principally do is manage those bureaus and try to shepherd that process along. That's the best way, I think, to describe what the roles that we do.
Thank you both. Jeff?
So I think one of the things a lot of people are interested in is when there's a transition, how much continuity will there be versus how much change? And in this instance, there's of course interest in, well, how much continuity relative to the Biden/Chair Khan's administration. But we also have the unusual circumstance of President Trump having non-consecutive terms. So I think there's also interest in how much continuity or change might there be relative to the first term. So if each of you could talk about those, maybe I'll leave it to you, but I'd maybe start with the continuity relative to the Biden administration, and then if you have any thoughts on continuity relative to President Trump's first term, I think we'd welcome hearing that too.
I think not to fight against the hypo. I'm going to start with what's different. For me, having been in Commissioner Holyoke's office, I saw firsthand significant issues, significant problems with the con FTC, and I think a big dramatic change is just the leadership at the top. When Chair Ferguson took over, there was a budget crisis. Things were not being run very well. That changed on day one, and I think I'm very glad to report that we're in a healthy situation in terms of both our budget and ongoing sort of management issues. I think another principal difference is that the chair sees fealty to the law as his number one priority. He doesn't see the law as a means to an end the way the con FTC saw that. So those are two, I think, dramatic and big differences between Chair Ferguson and the con era.
Yeah, I mean, jumping off on a significant difference, I think in the merger space, that's one of the clearest departures, really starting from the foundational principle that I think many people in the past administration thought that mergers were inherently problematic and that the agency should use all the tools at its disposal to slow down mergers, increase the cost, deter merger activity writ large. I think we take we recognize that mergers have a lot of enormous economic benefits, that they can really unleash innovation, they can increase efficiency, and so we don't have a hostility to mergers per se. We see our role as law enforcers. We have a statute that Congress has passed, as I mentioned, the Clayton Act. It's our job to enforce it. When we determine, based on our investigation, that there is a merger that's likely to harm competition, we will vigorously sue to block it and do everything within our legal powers to preserve competition in those markets. But we're also trying to make that determination of whether this merger is anti-competitive as quickly and efficiently as possible, so that if we decide, no, there's not a case here, then we see our role as to get out of the way, let the merger close, let the parties move forward, and hopefully unleash the economic benefits that come from that merger activity.
I think one thing just to build on that, one of the first things that the con FTC did was amend the mission statement. And there was a line in the mission statement about unduly burdening legitimate business. And to Dan's point, that's exactly what the MO was while they were there. And I saw that firsthand, whether it was on the consumer protection side or the competition side. I think another dramatic change is if we see a problem, whether it be consumer protection or competition, we're going to take action. But if we don't see a problem, we're not going to unnecessarily just throw sand in the gears to try to cause problems, because understanding our presumption is that markets are a good thing, and they can produce benefits for consumers and the public writ large. That was not an assumption that animated the con FTC.
And any thoughts relative to the FTC in the first Trump administration?
Yeah, I mean, I think the first Trump administration, I was at the Department of Justice for the tail end of it, and I think it's true at the FTC as well. In the antitrust space, there was a renewed recognition that government antitrust enforcement has a really important role to play in preserving free and fair markets. Competition delivers enormous benefits to the public, right? That public policy should promote and support lower prices, higher quality, more innovation. And free markets enable that. They provide the incentives that deliver those huge social benefits that that Congress wants. Congress has empowered us to enforce laws that promote that. So I think the first Trump administration in its tech investigations, like Jeff mentioned, the FTC obviously also filed a major tech lawsuit at the end of the Trump administration, as well as a lot of the more mundane or routine enforcement actions that were undertaken during the first Trump administration. Again, I think that spirit that we as the government have an important role to play in making sure that the antitrust laws are enforced and that competition is working well for ordinary, everyday Americans. I think that spirit is very much still alive at the FTC.
We're going to spend a little bit of time in a few minutes talking about some of the specifics of how this is playing out. I will say just To echo something that Dan said, as a merger practitioner, someone who does this every day for a living and counsels companies on what's in and what's out and how to get things done, I think the new approach just allows for much better business planning. There's a lot more clarity in the market, and that can be a very salutary thing, I think, for the economy writ large. But before we get there, I do want to hear from each of you, from Chris and then Dan, about what your policy priorities are for each of the bureaus of consumer protection and competition.
I can start.
And I guess, Chris, we're less interested in your view about the Bureau of Competition, and Dan, yours, the Bureau of Consumer Protection.
Fair enough.
Fair enough, yeah. For the Bureau of Consumer Protection, I think there's a, given the range of issues that, that we end up looking at, I'll focus on just a handful today. I think financial services is going to be, I think, a critical issue that we're going to be focusing on, in part because I think, in the past, the CFPB has taken a more active role in this space. And I'm also a financial services person by training, so it's something that I enjoy and like to work on. Fintech is another area that I think is an important area where the commission should be focused on. But taking a step back, it's important, at least in my view, to understand, or at least when we're using our enforcement resources, to appreciate that our role is to reinforce markets, not replace them. And so a big thing, and this echoes a lot of the same things that the chair has said, we're a cop on the beat, and we're not there trying to remake how businesses work. We're here to enforce the law. And when we're looking at acts and practices that are problematic, we're really trying to focus on tangible harm. And so whether it's financial services, in the fintech space, we're the principal regulator when it comes to franchise dealers. Those are all areas I think that are going to be really important for me as I'm, in terms of the next few years. The anti-fraud program is also another key area, reinvigorating that. It was something I think that took a back seat in the last 4 years, and I think reinvigorating that is going to be very important.
So on the merger side in particular, we are a cop on the beat in that we don't, walking down the street, we don't know what we're going to see. We don't know what mergers are going to come in on any given day, and we have to, we're statutorily obligated to look at them and evaluate them. On the conduct side and kind of thinking about our mission generally, though, we're very focused on industries that have the biggest impact on everyday Americans. So 3 to highlight are healthcare. Everyone is all too aware of how healthcare costs continue to eat up more and more of Americans' budgets. And in healthcare in particular, there's both the need to control prices because healthcare is becoming more and more unaffordable for most Americans, and also to make sure that we're driving quality and innovation, right? And competition has a lot to say to make sure that prices are going down while quality and innovation is going up. It's not, I don't think, surprise that the first antitrust case that got voted out after the change of administration involved the merger of 2 medical device manufacturers. Secondly, technology markets obviously continue to expand and mediate so much of both ordinary Americans' day-to-day lives, how we're spending our time, but also technology has infused itself into all these, to really every market that we haven't traditionally thought of as technology markets. I can't start my dishwasher without an app now. And so we want to make sure that both the inputs into technology markets, like semiconductors, are competitive and are driving the cost of goods down. And again, on the consumer side, the consumers have good choices where they can benefit from competition in the technology space. And then the third area I'll mention is labor. So I think the Supreme Court's most recent antitrust case involved labor markets, and courts have consistently held that laborers, workers, are entitled to the benefits of competition in the same way that consumers are. Workers benefit from employers competing for them because it raises wages, it improves training opportunities, improves workplace flexibilities, and so we're very committed to making sure that workers benefit from the same competitive dynamics that consumers are entitled to. One of the initiatives that the chairman has established since coming in is a joint labor task force between the consumer protection and competition parts of the FTC, where we're making sure that workers are, again, benefiting from competition between employers and also not subject to employment scams and deceptive hiring practices and things like that. And so that's been a really great initiative so far, and I think speaks to how important we see labor as in this administration.
All right, thank you both. I want to turn to regulation as a general topic and start with you, Dan. In April, the president signed an executive order about looking at anti-competitive regulations. And the FTC has a bit of history in this space. I'm interested in what you're thinking about looking forward to the rest of this administration about how the Bureau of Competition is going to operate, what it can accomplish.
Sure. So as Noah mentioned, a few months ago now at this point, the president signed an executive order on reducing anti-competitive regulatory barriers. And in my view, in the FTC's view, this is a really important initiative, and we're incredibly proud to be a part of it. So the EO requires the FTC to issue a request for public comment, which we've done. We received hundreds of comments from members of the public about identifying regulations that have impeded competition. And then the EO also requires all the federal agencies to review their own internal regulations, to look at the public comments, and to identify ones that entrench incumbents, that make it harder for new businesses to enter markets. There could be procurement-related rules and regulations that make it harder for companies to compete. And so this is a cross-government effort to review regulations, make sure that they are facilitating competition and not impeding it, which there's always the risk of when you have large incumbent firms that have a lot to lose by competition, and government provides, unfortunately, a mechanism that they can use to entrench themselves to keep out competitors. And so this is really a push against that, that unfortunate trend.
Chris, I've lost track of the number of consumer protection rules that under the Biden administration we issued at the FTC. You had mentioned rulemaking earlier. Talk to me about how the Bureau of Consumer Protection is thinking about rulemaking, and in particular, if you're willing to share with us how you might be thinking about any new rules or changes or rescissions of incumbent rules.
Sure. So I think everybody here is probably familiar with the president's executive order on 10 out, 1 in. That in and of itself it's a constraint that makes it difficult for any agency to be engaged in rulemaking in the near future. That said, I think that given the Supreme Court's decision in AMG, some of the anti-fraud rulemakings that the commission had contemplated, I think are potentially still worth considering. Take, for example, the earnings claim.
Can you explain for the audience what happened in AMG
Sure,
and why
yeah.
it's relevant to rulemaking?
Sure. Well, so AMG is, it's a pretty sordid history. It was a payday lender. The owner actually went to jail. His brother went to jail. But in effect, the pith of the case was whether or not 13B allows the commission to seek monetary redress. And the court, in a unanimous opinion, said no. The commission doesn't have authority under 13B to seek monetary redress. And this was an important element of the fraud program, and it was an important element of the Muris and Miller revolution, right? When they came in the early 80s, they said, okay, we're gonna stop with the rulemaking, we're gonna stop. At that time, the Washington Post even called the commission the second most powerful legislator in the country. It was given the number of rulemakings they were engaged in. And Muris understood that by tapping into this, what he thought was the 13B authority, what everyone thought was the 13B authority, we could bring cases in district court rather than going through the ALJ and be able to stop in its track fraud as it was happening, right? And provide redress to consumers. It was a huge win. It was a big reason why the commission became the legitimate commission. It was a big reason why the commission gained the legitimacy it did, was because of the fraud program and also because of changes on the competition side as well. So, going back to the anti-fraud program, because of the Supreme Court's decision, the correct decision, we have lost some ability to get monetary redress if we can't find a rule violation. So in the earnings claim setting, you have situations where direct sellers and other types of business opportunities make earnings representations to consumers, and that can cause enormous harm to consumers when it's done in that way. There was a case recently that we brought called I Am Mastery. It was an MLM. It was a pretty bad set of facts and circumstances. We estimated there was over $1 billion in consumer harm, and a lot of what they were representing to consumers was, we could teach you how to make tons and tons of money, trading stocks, trading futures, and whatnot. And it turned out nobody or hardly anybody made any money, and lots of consumers spent a lot of money in order to purchase the training services. So I think potentially looking or exploring those types of anti-fraud rulemakings, I think that that's worth considering.
I want to focus on one rule that got a lot of press in the last administration. That's the junk fees rule. One of the things that it requires is a version of price transparency. And I wondered, Chris, Dan, I want to come to you in a moment about this, but I wondered, Chris, how you think about that aspect of the junk fees rule.
Sure. So I think price transparency is critical for markets to function, for them to function appropriately. Now, I think the context here matters, right? It's not the case that price transparency, when done right, is forcing firms to engage in types of price advertisement that they otherwise wouldn't. Take an example: the tickets, right? Ticket sales were obviously one part of the rulemaking. What was going on was that these sites were advertising ticket prices, and they were saying, for example, here's a $100 ticket for such and such concert, right? It turned out, after you spent a series of clicks and minutes, when you got to the end, and I remember doing this several times when looking for tickets in Vegas, about right before the rule was passed, you get to the end and the price is marked up 30%. So that type of disguised or deceptive fee is problematic because it undermines price discovery and it undermines price competition. Now, I understand, and I think Dan will probably speak to this in a moment. We want to be careful about when and where we approach these types of instances of deceptive pricing. We don't want to be in situations where we're making it easier, for example, for competitors to coordinate or to price fix. But I think that when done appropriately, it is a way to reinforce markets. And I will say, one of the things that was problematic with the way that the FTC talked about this issue was they just, writ large, described fees as junk fees. And some fees can actually be pro-competitive and pro-consumer. Take late fees, for example. Late fees can, when properly disclosed, meter whether or not a consumer is going to pay on time, and also incentivize consumers to not only pay on time, but if they, for consumers that are not paying those late fees, they don't have to bear the burden of those that don't pay on time. So I think a nuanced approach is appropriate, but understanding that we need to be careful about the way we approach it.
Yeah, I mean, I think at a high level, the antitrust laws reflect the dynamic that Chris was talking about, which is that price competition is one of the foundational forms of competition. You want people to be able to comparison shop and choose the product or package of services that provides what the consumer wants at the price they're willing to pay. And it's important for consumers to know what that price is so they can make that decision. On the other hand, the antitrust laws are also very concerned about coordination between competitors, including on setting prices, and information sharing between competitors on prices, and ultimately price fixing, which is a crime. The antitrust laws have doctrines built in to address both sides of that pricing transparency issue.
All right, thank you both. I want to read a quote for the audience. "This new strain of antitrust populism may not disappear so readily. Certainly, the hardiness of earlier versions, which focused more on the evils of big trusts and the virtues of the small businessman, suggest that the desire to use the antitrust laws to promote social justice rather than to maintain competition will not quickly fade from the political scene. It is always hard to overcome the appeal of doctrines that promise economic justice for all." So that was Professor Ernest Gellhorn. He was writing in AEI's journal, Regulation, in 1978, right around the time that I was born. And he was writing about the Federal Trade Commission. I think it's safe to say that that quote could have been written fairly recently. So Dan, I want you to tell us where you think we sit today in the arc of antitrust history.
Big question. So
In 4 words or less.
right.
Yes or no?
Definitely yes. So I certainly agree with the quote that the antitrust laws are focused on harm to consumers in whether that's measured by, again, prices, quality, loss of innovation, that is the ambit of the antitrust laws, and the antitrust laws are not a panacea that addresses every possible social concern. That's why Congress exists. That's why there are other policymaking avenues for those issues to be hashed out, and the antitrust laws are not the tool to do that. I do think the word populist can be used, is often used a little bit differently today than maybe it was in that quotation. I do think that for a long time in antitrust, there was the perception, and well-founded in many cases, that antitrust was extremely technocratic and something that was done by PhD economists behind closed doors, and that ordinary everyday people weren't able to understand how antitrust issues were analyzed or decisions were made. I do very strongly disagree with that, and so if that is a populist view, then so be it. I think as conservatives, we should be building theories from the ground up, right? We should be basing our view of how competition is working in any given market on the ground actual facts, not based on top-down theories that may or may not ultimately fit the facts very well. There's the old line that if the facts don't fit your theory, get new facts, but we don't want to do that, right? We want to take markets as they are. We want to take the competitive dynamics in those markets as they are, and start from that basis. So I do think, to the extent that we as antitrust enforcers can be communicating in a way that the public understands, I think that is all for the good. I think the public does and can understand the effect of monopolies on their lives, the effect of anti-competitive agreements on their lives, and this is a kitchen table public policy issue that affects how much people pay for groceries. The FTC blocked a proposed merger between Kroger and Albertsons late last year, two of the biggest supermarket owners in the country. It affects how much they pay for medical care, as we talked about before, and people get it. When I was at the Department of Justice, we filed one of the Google suits that Jeff referenced, and sought a jury trial because we thought that ordinary people can understand these issues. They understand what a bully is. They understand what unfairness looks like in business practices. And so I think we as antitrust enforcers both should and are really making concerted efforts to explain to the public what antitrust means, how it affects their lives, and I think people are more than able to understand that.
So that's actually a perfect segue to the next thing I wanted to talk about. I'm going to pick on Dan for a while, then we're going to pick on Chris. You did something a little bit extraordinary recently, which is you issued a closing statement in a merger case, in the Mars-Kellanova case. And that was something we talked about when I was on the commission, trying to bring back closing statements. And as a practitioner of the law, it is very, very helpful, sort of being out there in the public and understanding what the agency is doing when that happens. And so I wanted you to just take a moment and share with the audience what led you to do that in the Mars-Kellanova case.
Sure, so Mars-Kellanova, for those who haven't followed it, is a proposed merger between two large food producers. And we issued a closing, so as I mentioned before, the parties filed before the merger could close. We opened an investigation into whether this merger would have anti-competitive effects. And ultimately, as we explained in this closing memo, we conducted a nearly year-long investigation, dozens and dozens of interviews with people from every different part of the food, the food markets, grocers, competitors, customers, and took depositions, really did everything that looked extensively at data, conducted a very, very extensive and thorough investigation. And given the importance of, as I said, these kitchen table issues where Americans are concerned about food prices and the cost of living, we thought it was important to make clear in public that this was a merger that we looked very closely at, but ultimately decided that we did not have a case that we could bring. And as I said before, as law enforcers, our job is to make that determination as quickly as we can, and once it's made, to let deals that don't violate the law close. Additionally, in this case, it was important also to note in the closing statement that many different antitrust enforcement agencies around the world were looking at the same deal because it's a huge, global deal that a lot of countries were looking at. And we thought it was important also just to remind folks that not only do different countries have different standards in terms of what constitutes an unlawful merger, but here in particular, the set of brands that they owned in the United States was very different from the brands that they owned and sold worldwide, and that was, again, we'll see what the other jurisdictions ultimately decide to do, but that was an important factual point that we wanted to make sure people understood.
Thank you. I want to come to what strikes me as one of the starkest differences between antitrust enforcement in the last administration and antitrust enforcement in this administration. And I think we're already seeing that difference is both at the DOJ and at the FTC, but you're not responsible anymore for the DOJ, and that is in merger remedies. And for folks in the audience, sometimes when there's an illegal merger or a merger will threaten competition in a particular market, you just block it. But oftentimes, there are scenarios where the merger is largely fine, even beneficial for the public, for consumers, but there's an aspect of it that creates a problem, and there might be a way to solve that problem. And that's called a merger remedy. There's a whole lot of writing on this, and we're not going to belabor it because I'm mindful of everyone's time. But I wanted you, Dan, to talk about kind of how you're thinking about the approach to merger remedies and the change, I think, that this administration is effectuating and how it's going so far.
Yes, I think this is a significant change from the Khan FTC to the Trump-Vance FTC, where, for the reasons that Noah indicated, we have, in the last few months, agreed to and filed settlements in merger cases that have allowed deals to close with conditions. Again, going back to our view that we are ultimately law enforcers deciding whether or not a given deal violates the Clayton Act. If a remedy resolves that issue, if the deal is no longer anti-competitive once a remedy is taken into account, then the deal no longer violates the Clayton Act, and we should allow the deal to close subject to the remedy. Now, the standards for what kind of remedy is sufficient to resolve competitive concerns, on the one hand, is going to be fact dependent, but that is a high standard. So the kind of remedies that traditionally are most effective based on the history of looking at these settlements over time are going to be divestitures of entire business lines that allow that business line to operate in to compete against the merged firm post-merger. And the buyer has to be a buyer that's in a position to continue providing that competitive constraint post-acquisition. It can't be a buyer that, for whatever reason, is incapable of actually continuing to compete in the market. So those are the kinds of issues that our compliance shop would look very closely at before, and the commission would look very closely at before any remedy would be agreed to. But in principle, if a remedy solves the competition problem, then we should allow the deal to close subject to that remedy.
Thank you. No, can I jump in here with just a follow-up?
Sure.
There was one recent remedy from the FTC that got some public attention, which was the Omnicom IPG merger. And I think that was a very interesting situation. I wonder if you can comment or share some thinking on that one.
Sure. So for folks who haven't followed it, Omnicom and IPG were our two large advertising agency holdcos, they're called. And in the advertising space, there had been this history of coordination, which was the subject of House of Representatives report, among other things. And under the merger guidelines, when there's an industry that is consolidating because of a merger and where there's a history of coordinated activity between the parties, that can be a source of anti-competitive harm. Here, the coordination that the House report focused on was concerted refusals to deal or agreements regarding not buying advertising on politically disfavored websites. And so the remedy in this case was an agreement by Omnicom and IPG to essentially not engage in that kind of coordinated practice going forward.
So sort of a non-boycott type requirement.
Right.
So I want to turn to another settlement on the consumer protection side, also to give Dan a break, and thank you, Dan. And that is the Walmart case. So this is a fraud-ish case that was brought during the Biden administration. I will note it elicited dissents from both myself and Christine Wilson, the other Republican minority commissioner at the time. The agency recently settled that litigation, and I wondered, Chris, if you could talk about that settlement and also more broadly the anti-fraud program as you see it moving forward.
Sure. So the pith of the practice in that case was the commission alleged that Walmart was assisting and facilitating telemarketing sales frauds, principally through money transfers. So if any of you have transferred money overseas, this is done by principally just a handful of companies, but Walmart entered the market sometime in the middle of the 2010s. So we settled the case, and we got some relief for consumers, but it had a unique posture given what happened down at the district court twice, and effectively, the goal that I had in trying to settle the case was trying to get some relief for consumers. Now, I think that the pith of the issue in the case, it represents enormous harm, ongoing harm to consumers, not from Walmart, but just money transfers or payment processing of scams and frauds more generally. We also had another settlement this year called Paddle that had to do with a payment facilitator that was operating as, it called itself a merchant of record. And it did that principally to evade payment facilitator requirements that are pushed from networks down to acquirers and then down to payment facilitators. And what happened in that case was they were facilitating a good deal of fraud, principally from foreign scammers. So this is an issue, and the chair wrote about this issue and highlighted some of these issues in his statement. And focusing on money transfers, I think, is going to be an important element of our positive agenda moving forward.
Great, thank you. We've got about a minute left before we get to Q&A, and I want to end with privacy. And I want to set the table a little for the audience. So data privacy is a huge issue. We've seen a tremendous amount of legislation all across the world, and I think most notably the General Data Protection Regulation in Europe, and a lot of similar laws being adopted elsewhere. We've seen attempts in Congress to address this issue, but for decades, the Federal Trade Commission has kind of been the tip of the spear in the US for privacy enforcement. And it's an interesting context because it involves the application of very broad principles, right, from 1938, unfair and deceptive acts and practices, mapped onto a constantly evolving, right, ecosystem of technology and its interaction with consumers, business to business, and so forth. I would imagine the FTC plans to still be a cop on the beat on privacy. How do you think about that role? And how do you think about that, enforcing a statute from nearly 100 years ago? Sorry, this part of the FTC Act is from 1938. I should have made that point, the Wheeler-Lee amendments. How do you think about enforcing old, maybe broad words on newer technologies and markets as they evolve?
Sure. So I think one way or one thing that we plan to do is enforce the privacy statutes that Congress has enacted, because that does provide a clean avenue by which to ensure that consumers' privacy rights are are protected. The FCRA, I think, is a great example of that. It was the first privacy statute that Congress wrote, and I mean, like any statute has its flaws, but I think largely speaking, it's been beneficial for consumers. I think Section 5, the big issue, the big problem that the FTC had was that they wanted to create rights and obligations that Congress has not created. And if Congress decides to pass a privacy legislation, we will enforce it. But for right now, we have Section 5. I agree that it has broad meaning, but Congress has, in the cases have suggested that there are metes and bounds for both unfairness and deception. Unfairness is really just the rule of reason, and depending on how you define the act or practice, you have to do a cost-benefit analysis and determine whether or not there are net benefits for consumers due to the practice. I think we saw, something like 25 unfairness counts during the FTC, and a lot of them just truncated the unfairness analysis by avoiding the cost-benefit analysis entirely. Deception, I think, it's about materiality, and it's about how whether or not reasonable consumers are affected by the omission or the express statement. And I think the metes and bounds there do provide a lot of authority for us to be a cop on the beat when it comes to privacy. And I think you're going to be seeing us active in that space, but giving meaning to the words that Congress passed. And we have to meet the standard of unfairness if we bring an unfairness count. And I think that's what you'll see us do.
Great. So we're in this mode where there's so many things we'd like to talk about, but I want to give the audience a chance to get in on the act at least. If not, Noah, you and I will continue. But if there are questions from the audience, why don't we start here and then we'll go there?
Hi, Dan Gilman from ICLE. A couple of you know me. I was at the FTC for 16 years, 2006 to 22. I wanted to circle back to a point that came up when we were talking about, well, I suppose populism, but also continuity, because one thing that always struck me, certainly under Joe Simons, but for 20, 30 years before that, I think this is a great panel. I think this has been very useful. I'm sorry that AEI ran out of chairs, so there's no Bureau of Economics representative here.
That's my fault.
But I'd like to hear a little bit more about the role of economics, because on the one hand, everything Daniel said about high-level theory and fit seems reasonable to me, but at the same time, I think both the policy and enforcement work that had been done for decades really depended on the work of FTC economists in very critical ways. These were mostly not theoreticians, right? Applied I/O economists was the biggest group. Applied consumer protection economists was the next biggest group. So, in studying trade-offs and hard things in some of these initiatives, the anti-competitive regulations thing is not new. It had been a concern for the FTC for decades. We want to sort out trade-offs, right? And it's hard. Same in privacy enforcement. I mean, there are easy cases. That's great. Bring the easy cases. But how do you, as an enforcement bureau director, how do you see the role of the Bureau of Economics? What are things you'd like to get from the Bureau of Economics to help you going forward, either in not just in individual cases, but sort of in making enforcement policy?
So just very briefly for everyone who's not doesn't understand the FTC intuitively, there are two enforcement bureaus. Those are the ones represented here. There is also a Bureau of Economics, and the Bureau of Economics advises the enforcement bureaus and the commission on various aspects of the cases. Sorry.
So, from my perspective, it's critical to the work that we do, and we have a great relationship with the Bureau of Economics. We've implemented a series of changes that reflect, I think, the way things used to work, but frankly, even more aggressively using economics. The FTC was not interested in economics, obviously. So it's critical for our work and what we do. And in fact, we're seeing as we have a lot of tech-heavy investigations. very data heavy, econometric heavy. So the economists are heavily involved in our work, and even at the CID stage, because and this is something that I've talked to my team and BE about, which is understanding trade-offs at how you use enforcement resources, right? I think that's critical. I also say, building off something Dan said earlier about using facts on the ground. I mean, my favorite school of thought is the new institutional school of thought, and that's Coase, Williamson, Alshian, Dempsitz. Those guys they were talking about the real world, right? They weren't talking about, Dempsitz coined the nirvana fallacy, right? That's blackboard economics. That's unhelpful. So I think economics done right in that way, which I think that's where the commission was at its best, frankly, was having new institutional style thinking. To me, that's where I think we need to be, which is real world evidence, looking at the real world, looking at the institutions. We're talking about price transparency, understanding, there are circumstances where we want to be careful about, how prices are being revealed. That's just institutional economics, and I think that's critical, and it's a priority for us.
Yeah, I completely agree with that. We work extremely closely with the Bureau of Economics on all of our cases. Increasingly, we use Bureau of Economics economists as testifying experts in trials, so we are hand in glove with BE. As a enforcer who, we have a lot of cases in litigation. We just finished a major trial against Meta a few months ago. I do think that it is critical that we use the economics to reinforce and talk about the underlying facts on the ground competition story in a way that judges can understand. Again, I think there was perhaps a stereotype, but with some truth in it, that antitrust trials were a battle of two economic experts, both similarly credentialed, saying necessarily incompatible things, and judges were kind of left unsure how to sort out those issues. And so from a litigation perspective, from a trial perspective, I think integrating the economic testimony with the broader story that we're telling about who's being injured, why, what's broken down in terms of competition, I think we have gotten better at integrating, again, the economics into those stories that we're telling in court as we've done more litigations in recent years.
We come over here, this gentleman in the middle.
Yes, my name is Roger Coachetti. I am an author, an editorial writer on technology policy, and a former non-legal business executive for ComSat, IBM, and VeriSign. And first I'd like to thank AEI and the panelists for structuring this in a way that's aimed towards people like me who are not legal FTC experts. It's very helpful to understand these. But one of the issues that's floating around both enforcement bureaus at the FTC and elsewhere that is continuously confusing to many of us is jurisdiction. I remember a long time ago when I was in college, a professor said, it's very easy. If the peddler rides his horse into town and tries to sell apples in that town, he knows that he's purposely availed himself of that town and therefore subject to the jurisdiction of that town. And by that definition, every website is written into every town and every country in the world. And the issue that I think it could help many of us understand is, how does the FTC today view the subject of jurisdiction? If the FTC of Brazil declares that something Amazon is doing is illegal, do we recognize that? If the FTC declares that something that, pick your favorite foreign firm, is doing is illegal, should they recognize that? And if it's only, well, just tell me where the headquarters of the company is, then everybody will go to Liberia. We'll have a flag of convenience for the internet. So how do you deal with the issue of, as the world is completely integrated, I don't know which country these website is from, and how do you deal with other countries who are addressing the same issues you are, but from the perspective of their people? Thanks.
Sounds like an OIA question. You want me to try?
Yep.
I think, so the commission has a rich history of global advocacy. I'm not sure how far back it goes, frankly. I was joking, it's an OIA. We have an Office of International Affairs, and they principally focus on international outreach and coordination. We work with governments across, or agencies across the world on enforcement actions, not partnering, but we will provide assistance through, there's a statute called Safe Web, where we'll provide information sharing and whatnot. But I think your question, setting aside the personal and subject matter jurisdiction questions, which I think treatises have been written about. The policy issue I think is interesting insofar as I think we've historically been an agency that has tried to advocate on behalf of the way we do antitrust and the way we do consumer protection. I think that's important, and I think I expect we'll be doing more of that in the future.
Yeah, the FTC has historically advocated for basically the law enforcement case-by-case approach that we follow here, as opposed to more of an ex-ante regulatory approach where you're more likely to inhibit and prevent potentially pro-competitive behavior. So that's one area of advocacy that we've been involved in the not too distant past. In terms of our view of the scope of our jurisdiction, the antitrust laws cover essentially conduct that is in or affects consumers in the United States. And we view our role as making sure that we are protecting consumers in the United States, which is part of why in the Mars Kellanova closing statement that Noah asked about before, we made clear that we care about how's this merger going to affect competition in the United States? Is it going to harm consumers here? And other countries are going to have to make their own determinations, not only because they have their own legal frameworks, but because actually the products are different, the markets are different, consumer preferences are different. And so we can take care of American consumers, we're going to protect American consumers, we're going to do everything we can, but really we're not able to police the world in that way.
Probably have time for one more, so why don't I go back here? If there's time, I'll take one more, but let's see if we can at least get one.
Chris with MLEX, thanks for the conversation. This question's for Dan, and it's sort of piggybacking off what you just said about the role of economists and telling compelling stories to judges. This morning, the DOJ filed a statement of interest in a case against media organizations, arguing that suppression of competition in the marketplace for ideas is a cognizable antitrust injury. And I think most economists would agree that quality is a dimension of competition, but some experts in this area have raised concerns about the lack of any objective measure of quality, which can take many forms. So I was just hoping you could talk a little bit about how you think about these issues.
Yeah, I have not obviously seen anything that's happened in the last couple hours while we've been here. But in general, again, price, quality, innovation, these are all well-established dimensions on which courts can look at harm to consumers arising from anti-competitive behavior. Quality it's necessarily product and market specific, right? The quality of that a healthcare provider is providing is going to be different than the quality of a website. But in both cases, there are dimensions of quality that can be quantified and can be reflected. Consumer surveys are one possible way of measuring quality, and a lot of times in markets, businesses care a lot about quality metrics of various kinds and track them very closely. If not the business itself, then sometimes their customers or their up or downstream trading partners will measure how often did you deliver this on time, what were the quality metrics. So it's market specific, it's case specific, but there are both qualitative and quantitative metrics that can feed into that quality determination when deciding whether, again, in addition to price, in addition to loss of innovation, things like that, there's been a loss of quality.
Do we have time for one more? Sure. Right here. Then we'll wrap up.
Thanks, Jeff. Thank you for doing this. Dave Grimaldi, Direct Selling Association. Chris, great work, great insights. The whole team there, Lois Greisman, they've been great to work with. We very, very quickly, as you're working on their earnings claim rule, Delaware legislature took a similar path in the past couple of months, introducing a bill that would have had massive unintended consequences for our industry, premised on the same theory that you discussed earlier that we take very seriously, which is misrepresentation and the creation of a false expectation in a consumer about what that earning potential could be. You've previously said that you follow data, that you want to look at the actual numbers and where the fraud is. We do too, and we condemn all bad actors, and we're working to eradicate them hand in hand with you. The future of the rule, given the president's kind of roadmap that all of you laid out earlier, any thoughts on this year? And again, we'd like to continue partnering with you on it going forward.
Yeah. So I mean, I can't speak to specifics, but I think just generally speaking, I think everything you said, I'm in agreement with. We need to be data focused, and the data needs to drive where we land on anything that we do, whether it's a rulemaking, whether it's a specific case. I mean, I just say in the abstract, I don't see why any legitimate business would be averse to a rulemaking that just simply says, you can't mislead consumers with your pricing. I think obviously there's more to it than just that, but that's just my sort of prior when it comes into thinking about this. But
All right, well, I apologize to those of you who didn't get to ask questions, but thank everybody for being here, and I especially want to thank terrific discussion by our guests. So thanks to both of you and to Noah.